The budget system in the European Union. The European Union had an agreed budget of the 120 120.7 billion euros for the year 2007 to and 864.3 billion euros for the period 2007-2013, representing 1.10% and 1.05% of European 27 GNI forecast for the respective periods. In 1960, the budget of the European Economic Community was 0.03% of the GDPs. In the 2010 budget of the 141.5 billion euros, the largest single expenditures items in it is cohesion and competitiveness with the around 45% of the total budget. Next comes agriculture with the approximately 31% of the total. Rural development, for environment and fisheries takes up around 11%. Administration accounts for around 6%. The European Union as a global partner and citizenship, freedom, security, justice bring up the rear with the approximately 6% and 1% respectively. The Court of Auditors is legally obliged to provide the Parliament and the Council with a statement of assurance as to the reliabilities of the accounts and the legality and regularity of the underlying transactions, and the court also giving opinion and proposal on financial legislation and anti-fraud action. The Parliament used these to decide whether to approve the Commission handling of the budget. The European Court of the Auditors has signed off the European Union accounts every year since 2007, and while making it clear that the European Commission has more work to do, has highlighted that the most of the error take place at national levels. In their report on 2009, the auditors found that the 5 areas of Union expenditure, agriculture and the cohesion fund were marginally affected by the error. The European Commission estimated in 2009 that the financial effort of the irregularities was 1863 million euros. Legal system and justice in European Union. The legal system and the justice in European Union is based on a series of treaties. These first established the European Community and the European Union, and then made amendment to those founding treaties. These are power-giving treaties which set broad policy goals and establish institutions with the necessary legal powers to implement those goals. These legal power include the ability to enact legislation which can directly affect all member states and their inhabitants. The European Union has legally personality with the right to sign agreement and international treaties. Under the principle of the supremacy, national courts are required to enforce the treaties that their member states have ratified, and thus the laws enacted under them, even if doing so requires them to ignore conflicting national laws and even constitutional provision. The direct effort and supremacy doctrines were not explicitly set out the European treaties but were developed by the Court of Justice itself over the 1960s, apparently under the influence of its then most influential judge, Frenchman Robert Lecourt. Courts of Justice in European Union. Judicial branch of the European Union, formally called the Court of Justice of the European Union, consists of two courts, the Courts of Justice and the General Courts, and the Court of Justice primarily deal with the cases taken by member states. The institutions and the cases referred to it by the courts of member states. Because of the doctrines of direct effect and supremacy, many judgments of the Court of Justice are automatically applicable within the internal legal order of the member states. The General Court mainly deal with the cases taken by the individuals, companies directly before the European Union courts, and the European Union Civil Service Tribunal adjudicated in disputes between the European Union and its civil service. Decision from the general courts can be appealed to the Court of Justice, but only on a point of law. Fundamental rights. The treaties declare that the European Union itself is founded on the values of the respect for the human dignity, freedom, democracy, equality, the rules of law, and the respect for human rights, including the rights of the person belonging to the minorities in a secure society in which pluralism, non-discrimination, tolerance, justice, solidarity and equality between the women and men prevail. In 2009, the Lisbon Treaty gave legal efforts to Charter of the Fundamental Rights of the European Union. The Charter is a codified catalogue of the fundamental rights against which the European Union legal acts can be judged. It consolidates many rights which were previously recognized by the Court of Justice and derived from the constitutional traditions common to the member states. The Court of Justice has long recognized fundamental rights and has on occasion invalidated European Union legislation based on its failure to adhere to those fundamental rights. Signing the European Convention on Human Rights is a condition for European Union membership. Previously, the European Union itself could not adhere to the convention as it is neither a state nor had the competence to adhere. The Lisbon Treaty and the Protocol 14 to the ECHR have changed this. The former binds the European Union to adhere to the convention while the latter formally permits it. The European Union is independent from the Council of the European and they share proposed ideas especially on rule of law, human rights and the democracy. Further, European Convention on Human Rights and European Social Charter, the source of law, the Charter of Fundamental Rights are created by the Council of European. The European Union also promoted human rights issues in the wider world. The European Union opposes the death penalty and has proposed its worldwide abolition of the death penalty. Its conditions for the European Union memberships.